Due to your suggestion, I will talk on euthanasia, not the whole title, which is a very sensitive and controversial topic in contemporary law. And it's not merely a legal phenomenon, it sits at the cornerstone of medicine, ethics, philosophy, and many other disciplines. And the main dilemma here related to euthanasia is how to comply both with the Article 2 and Article 8 of the European Convention on Human Rights. The Article 2 is actually at the heart of all human rights systems, and Article 8 encompasses autonomy and decision-making on one's own life. My presentation is divided into three main parts. The first one is related to the definition of euthanasia, the second one to the national experiences, and the third one is related to the European Court of Human Rights cases. So end-of-life issues in general in the original scientific papers are divided into euthanasia and assisted suicide. But in the guide on Article 2 of the European Convention on Human Rights, we have part issues related to the end of life, which is divided into euthanasia and withdrawal of life-sustaining treatment, which further means that European Court doesn't recognize passive euthanasia in that term, because the withdrawal of life-sustaining treatment is actually passive euthanasia in specific papers. Euthanasia itself nowadays implies medical context. It was actually only easy death in the earlier times, but nowadays it is in medical context, and it refers to a terminally ill patient who suffers from constant and unbearable pain with no hope of improvement. One very important element of euthanasia is that we have here expressed patients' wish to end their own life, or in some cases, such an unequivocally assumed will. It means that in some situations, patient isn't in a situation to actually express his own will, and this concept is justified mostly as an act of mercy. Active euthanasia itself means the implementation of the injection of lethal dose of medicament, and passive euthanasia is actually passive act or omission of an act. For example, the withholding or withdrawal of life-sustaining treatment, or switching off ventilator, or stopping artificial nutrition, for instance. Assisted suicide itself is the concept that is considered to be similar to euthanasia, but not the same. And the main difference here is that the patient himself actually is the last activity in the process is on his own. He have the help of the another person, the family member or the medical professional, who will prescribe him lethal dose of a medicament, but he will use it on his own. And assisted suicide is legalized in many countries, for example in Switzerland, where we have many ways in which we can implement this concept, and there it is allowed only without selfish reasons. Germany, Italy, Austria, and etc. Have actually this concept recognized in their constitutional frameworks. Also, there are a lot of countries where the euthanasia laws are in progress. For example, France, where assisted dying law is in parliamentary progress. We had also in Portugal many constitutional and political challenges regarding euthanasia. Slovenia, Cyprus, Malta, they all have active debates on this topic. On this map, you can actually see the countries where we have some form of end-of-life issue legalized. And most important for this topic is that there are also countries that legalized euthanasia. The first one is the Netherlands. It is the first country to legalize euthanasia in 2001 under strict conditions with well-considered request of patient who is in unbearable suffering. In the following year, Belgium legalized euthanasia in 2002, and here it is very important to know that Belgium actually extended a basis for euthanasia to minors, mostly in 2014, which was very controversial at that time, but it is nowadays also. Then Luxembourg legalized euthanasia in 2009, and Spain most recently, in 2021, legalized Assisted Dying Act with strict eligibility and medical review procedures. In all these countries, the main conflict related to the euthanasia is how to actually comply both with the Article 2 and 8. Article 2 means that we need to safeguard human life as the main object of human right to life, and it is hard to actually think that a potential human right to die could be actually based on this right. States have positive obligation to safeguard life itself. And Article 8 means that we have right also to the autonomy and to the decision-making on how and when to die. In relation with Article 8, we can also mention the other provisions, such as Article 3, 9, and 14. Prohibition of torture, inhuman or degrading treatment is regarding to the patient that are forced to endure suffering without euthanasia. Freedom of thought, conscience, and religion is related to the family members or medical professionals who don't want to be involved in euthanasia process on moral grounds. And prohibition of discrimination could be mentioned when there are patients that don't have equal access to the euthanasia or assisted suicide. Article 2 actually mentioned that no one shall be deprived of his own life. There are limited circumstances where it is allowed, but there's nothing related to euthanasia. So it's very complex here. And everything that I've said is well explained through the European Court cases. The first one here is Brity versus United Kingdom from 2002. A terminally ill patient requested immunity for her husband if he helped her die, which was refused by UK authorities. And the main impact of the judgment of the European Court was that protection of a life should be over autonomy. And this case set baseline for later cases on euthanasia and assisted dying also. The next one case is Gross versus Switzerland from 2013. Elderly woman wanted to gain assisted suicide under Swiss law, which was not allowed to her, and she argued that her rights were violated. The court actually highlighted the need for legal clarity in assisted suicide laws in countries where actually that law is present. And that is something that we need to imply in all cases where we have some form of end-of-life issue legalized. The first two cases could actually bring us closer to the decision or conclusion on how European Court functions here. European Court relies mostly on the margin of appreciation or by discretion given to the states on moral ethical issues such as euthanasia. In all cases, European Court requires strong procedural safeguards, and even though that we talk on different countries, we can conclude that jurisprudence shows gradual shift from the Brity case, where we have conclusion that euthanasia isn't something that could be addressed to the Article 2, and that right to autonomy is in a lower level than Article 2. But in the next cases, we will see something different. For example, in Lambert versus Ferenc case, we have a patient in vegetative state after a road accident, and the family members argued if he needs to continue life-sustaining treatment. French courts authorized withdrawal, and that's why this case went to Strasbourg. The European Court actually judged that there was no violation because France had actually strong procedural safeguards such as different medical opinions, judicial review, and the respect for patients' dignity. And here we have the confirmation that states may be allowed to legalize actually withdrawal of life-sustaining treatment or passive euthanasia in a different words, without breaching Article 2 if safeguards in national laws are in place. And the last one, and maybe the most important case here for the topic, is that is Mortier versus Belgium from 2022, where we had a patient who underwent euthanasia under Belgian law, and her son argued that her rights were violated because there was the lack of safeguards. Even though that here was presented also the judgment that there was no violation, the court held Belgium's safeguard actually sufficient to meet Article 2 obligations, and he explicitly accepted euthanasia as convention compatible if there are robust safeguards. So from one state to this state from the same court, even though that we are talking to different states, I think that it is very important to mention because we don't have national, international standards on this topic. And this evolution from Pretty to Mortier case brings us closer to key points here, that European Court actually relies mostly on margin of appreciation and proportionality tests, and that we have, as it was mentioned in all cases, we must have a clearer scope of Article 8 in all countries, no matter if there is a legalized euthanasia or not. And this should be actually understood as a minimum procedural safeguards as a European standard. So this all brings us to the final considerations, that for the future we need to be aware that human dignity as the main value of all human rights should be considered as a common denominator, and that procedural safeguards should be the main bridge between life protection and autonomy. And this is because we need to be aware also that medical advances and demographic changes, we will have older and older population, will intensify end-of-life debates, and we will need to consider this topic. We will need to implement it in our national laws, because the European Court's role will grow, and European Court will likely serve only as an arbiter of minimum European standards that we will actually shape, requiring states to ensure clarity, legal certainty with the protection of vulnerable persons. I think that time was very short.
Definitely.
Thank you for your attention.